Emilie, just explain, why did we take the case?
Well, because at the heart of protecting the North Sea and ecosystems, habitat, species, ecological processes, is to remove damaging activities which prevent recovery of these ecosystems. And one of the biggest threats to marine ecosystems, unfortunately, still is, after 150 years, trawling. So after 17 years of going back and forth with the respective governments who have to regulate fishing on the Dogger Bank, we decided to take them to court.
And the Dogger Bank is a marine protected area at the very heart of the North Sea ecosystem.
Yeah.
Where we in the UK, you'll be pleased to know, have already kicked off bottom trawling out of 98% of it. So we're in the unusual position of being the environmental good guys, and the Netherlands, which kind of has a reputation actually of being kind of quite enlightened, is actually one of the worst in this situation. Certainly, only protecting just over a quarter of it. Yeah. If we go to the kind of court case itself, you had quite an important role because you were kind of sitting there at the front next to our excellent counsel, Bondine. Mm-hmm. What was that like? Because you kept being asked very detailed questions by the judge.
Yeah. Well, it was very interesting. Obviously, a lot of preparation goes into going into such a legal procedure, but we've been building up this evidence and the science for over a decade now. And so it was very important to be spot on all the latest knowledge. So that my role was really to present the ecological evidence, to present the evidence on trawling on the Dogger Bank, to have those numbers at hand. But I think this procedure was more about really the legal arguments were more prevalent rather than the ecological evidence, because really first we need to basically hash out whether fishing requires a license to fish inside the Natura 2000 area, the Dogger Bank. And then comes the impact assessment or the appropriate assessments, which will surely show that they have a significant impact, and so they should not be allowed to have a license to fish inside the Natura 2000 area. But for me, it was really nice because the cases can get quite dry, and I'm a marine ecologist. I'm also a diver. I'm quite passionate about the area. And so for me, it was very important to present also what is really at the heart of the matter. What is this really about? And it's about a seabed that is protected for corals, for anemones, for sharks, for rays, for all sorts of fish, but also the marine mammals, the seabirds. And what are we allowing to happen? Even since 2009, when the Dutch government was supposed to prevent deterioration from happening, which did happen, which did occur, what's really at stake here? And so I was able to show the judges what trawling looks like, the tons of chain mats that, trawl through the seabed, which prevent recovery from happening. So for me, that was important to me, is to really state, what's at stake here.
I think that's really important at any of these pieces of litigation. If you go in and try and argue the general point, the marine environment is badly protected, you won't get anywhere. You have to have the specific examples. You have to have that deep knowledge. And certainly from my perspective, sitting just behind you while you were so busy, that really came out, that we had this vast body of evidence that you'd managed to create, and then just be able to pull pieces out immediately. And I mean, for all trial lawyers out there, that's kind of a dream, really, that you've got somebody there who actually does know what they're talking about, who could pass the right piece of paper at the right time.
Well, I hope I was a good sidekick to Bondine, but very happy also with Bondine and being very well prepared. And we're involved in a number of legal cases now with our government, because unfortunately a lot of damaging activities other than fishing are happening across marine protected areas in the Dutch North Sea. So we've unfortunately been forced to take the government to court. But in doing so, for us, it's very important to focus on there being clarity, because a lot of these discussions, legal discussions, have been going on for decades. And I think that's the bonus, that's the win, even for the fishing industry, at least at this point, when the decision comes, we'll know how we have to interpret this Habitat Directive, how we have to implement it in our Dutch legal system. And so I think it will be important for all of us to have clarity how to effectively protect these marine protected areas.
Yeah, I mean, I think clarity is the whole thing as well. And just my final reflection on it was how quick it was. I mean, a UK case like that would normally last a couple of days. We were in and out in an hour. But I did think that the judges got to the point. What's your final reflection?
Yeah, I think they asked the exact questions that we've been asking the government for many years. What is your thinking? How do you interpret this law? Because we didn't get anywhere, and I think because of the court now asking these questions and the government having to respond to that will bring us to the next step and will bring us closer to understanding how to interpret the EU law. And I'm very optimistic as well, because I think the questions were spot on and they were very important in terms of getting to, it was almost like an onion that was peeled off, like all these sub questions leading to the bigger argument, like and the bigger question, like how does this sit? So for me that was very interesting to kind of witness. And I hope we did a good job. I hope we presented our case well, and that we have so much evidence, which is interesting because it's also a transboundary project in that sense that we've been working with ClientEarth, with Blue Marine Foundation, with Ark-Rewilding. We have international coalitions, and to us that was also, for me personally, I think working with you guys for so many years has been really amazing, because we've worked on the body of evidence for over 10 years, and today was really a landmark day where we sat in court together, we presented our case before the court. It was a long time coming, and I'm just really happy that it worked so well.
I was quite reassured by what we heard in court today. The judges had done their homework. They're well briefed, and they were really diving straight into the key legal questions, and I thought that was very reassuring, that they were really taking our case seriously. And I thought our lawyer Bundine did a very good job putting forward our case, and so I think we'll get I hope we get a good ruling in 6, maybe a few more weeks.
I think my reflection is firstly how different Dutch law is to UK law. I mean, the judges had read a huge amount, and they asked a series of questions rather than people having to present their position, and that's what's very different to the UK, and probably the same as Ireland as well. And my other kind of reflection was essentially the substance of the cases around kind of jurisdictional tennis, with everybody sort of admitted that the Habitats Directive needed to be applied, but then there's the question of who actually has to do it. What was your? I mean, we don't want to go too much into the substance of the case because it's not really appropriate until it's done. But yeah, there's that framing of it was really interesting, particularly coming at it from a different jurisdiction. What would your kind of EU head think of it like that on that?
The one thing that I was definitely reassured about was that I think the judges had a clear understanding of the Habitats Directive from an EU law point of view, and how it's supposed to be transposed into Dutch law. Many times we've been involved in court cases in other countries, and really the judges tend to be very focused on national law, and often it's almost as if EU law is a distraction, when actually it's the converse that is the case. It's the EU law which is the higher in the hierarchy. So that's really the key. It's the key law that needs to be complied with, and the judge had a very good understanding of that, and he had a very good understanding of how the Habitats Directive is supposed to be working in this case. And fundamentally, it's not the most complex, insofar as that it says if you have a destructive activity or an activity that might be destructive in a protected area, then you need to do something, you need to do an appropriate assessment. And I think there are lots of sort of things under the common fisheries policy, which we don't have to get into in too much detail now, but the fundamental point remains the same about you're not supposed to be allowing these types of activities in protected areas. And I think the judge had a very good sense of that, and I was happy to see that.
And I think actually just generally, I think this case then is going to be one to watch if you're interested in the Habitats Directive, if you're interested in European jurisprudence and who does what, where, when. And so, yes. And just finally from me, I think the other thing is that, what was very clear was that it wasn't a kind of headline-grabbing conservation piece of litigation. This was definitely something that was important, and it was taken seriously by the Dutch judiciary, which was a wonderful thing to see.
Yeah, I mean, absolutely. We weren't here filing a case just for the sake of it and trying to create noise for no reason. We have a very serious case, and it was pleaded very seriously. Our lawyer was serious. Everyone involved in it is taking this very seriously, and that was reflected in the courtroom today. The judge was taking it very seriously, and he asked a lot of very probing questions and good questions to the lawyers, our lawyer and also the government's lawyer.
So Floris, how did you think the case went?
I'm very optimistic about it, because I thought the three judges, but the chairman in particular, was very well versed with the file. He knew exactly where, especially the government's weak points were, weak arguments, and the way he questioned the government about those points told me so much about what he actually was going to write about, because he really set them up and then put them into a position where they had to defend themselves.
Yeah.
And I think they didn't do a great job at that, and he could come back to that later on in the questioning. So I'm very optimistic.
Yeah, it's a very interesting thing. For people who've not been in the Dutch inquisitorial justice system, I definitely haven't. I think that thing of a very, very active judge kind of making probing questions. Of course, you don't know where that's going. Do you?
Right, because at the same time, it's still a very technical case. And that's also how the judge, the chairman, from the start said he was going to approach it. He was not going to talk about how destructive bottom trawling was. It was really the legal questions that were at the heart of this hearing now. And of course, it's a difficult case. So yes, we might win on a lot of points, but it doesn't mean that it's in the bag.
Yeah, because administrative law is like that. There aren't really winners or losers. You're trying to map a way through the legal system so that decisions are made. And I think that's probably why it's going to take so long.
Well, at the same time, I think, it's crystal clear, you have to apply the Habitats Directive. But the complication is, how does that work with the common fisheries policy? And they have to address the arguments that the government raised, where they say, that's up to the European Commission, etc. So they have to tackle all of those arguments, even if they're rubbish. We think they're rubbish. But that's, in the judgment, it has to be. They want their judgment to be appeal-proof as well. No court likes to be overruled by a higher court.
And do you think there's a chance then that this will actually get beyond the matter at hand and have some sort of sense of precedence across the European Union, or is it we're going to be stuck in a local decision? What do you think?
I think we are instrumental in trying to achieve that. I think it's not going to be by itself, because I think no state wants to do this voluntarily.
Yeah. Okay, so watch this everybody, because this is the start of something potentially very interesting, particularly for sort of European legal scholars and people interested in the marine environment and even the fishing industry, because ultimately these things, better protected environment leads to more fish.
That's the whole idea. And it's about Natura 2000 areas. We're not against fishing or anything. It's about better protecting of areas that on paper are already protected, but in practice are not.
Thank you.
Thank you too.